This is the Construction Leading Edge podcast from constructionleadingedge.com. My name is Todd DeWalt, and my job is to help construction business owners take their business to the next level. In this podcast, you're going to learn from a construction attorney named Philip Siegel, and he specializes in helping general contractors, subcontractors, and suppliers stay out of and get out of trouble when it comes to labor and employment law issues, OSHA citations, contract consulting, payment disputes, and all sorts of construction litigation. Here's some of the stuff you're going to learn about from our conversation with Philip. What is what's known as the unforeseeable employee misconduct defense you can use to respond to an OSHA citation? Why should you do drug testing? Some people say that their competition seems to take anybody, even if they can't pass a drug test. So why should you do drug testing? How should you think about drug testing? Philip's going to share one tip you can use to avoid payment disputes and get paid faster. We also talk about some things you need to be aware of as it pertains to medical marijuana. And then what do you need to know if you work in a state with legalized marijuana? There's some very important policies you need to have in place and things you need to know about. Also, are they an independent contractor or are they an employee? Philip's going to give you some advice on how to stay out of trouble there. Philip's also going to share the top 3 employment mistakes contractors make based on his 20 years of experience. And then lastly, there's one thing that every contractor should do today or this week to avoid getting in trouble with a federal agency that is ramping up activity right now. This is going to be a great interview. You're going to learn a lot, but let me share a couple of things with you before we get into the interview. If you own a construction business and you want to increase revenue 25 to 50%, if you want to eradicate the chaos in your business and streamline it and turn it into a well-oiled, profitable machine, then this is for you. I want to invite you to take advantage of a special offer for a free business breakthrough coaching session where you and I are going to get on the phone and we'll work together to help you create a crystal clear vision for what ultimate success looks like for your business and the lifestyle that you'd like for your business to provide for you and your family. We're also going to uncover some of the hidden challenges that may be holding you back or even sabotaging the growth of your business, and as a result, keeping you working too many hours and not getting the results you want. And when we're done, you're going to walk away from this session renewed, re-energized, and focused, maybe even inspired to get after it and turn your business into a highly profitable, revenue-generating, well-oiled machine. So if you want to take advantage of this limited time offer for a totally free business breakthrough coaching session, then all you got to do is go to constructionleadingedge.com/call. That's constructionleadingedge.com/CALL. And one more thing for you, if you own a construction business or you're planning on starting a construction company in the near future, I've got a free video series I want to get in your hands. Have you ever wondered, how do the big successful contractors do it? How do they grow consistently? Why don't they have cash flow issues? What are they doing that you're not? Well, I've got a free video series called The Secret Strategies of Successful Contractors that I want to get in your hands. And here's what you're going to uncover in this free video series. One hidden cost that causes a lot of contractors to bleed cash and they don't even know it. There's this new way of thinking that will help you drive revenue, deliver projects on time, and ultimately grow your business and take it to the next level. You'll learn about some of the things that big contractors do to succeed that very few small to medium-sized businesses do. And lastly, you're going to learn why some of the biggest problems you're facing may not be problems at all. So if you want to get this free video series, all you have to do is go to constructionleadingedge.com/owner, OWNER. Click the big red button that says, yes, send me the information, and you will learn some of the secret strategies of successful contractors. Now, without further ado, here is my interview with Philip Siegel. Philip, thanks for being on the podcast. Let's jump right in. What is the unforeseeable employee misconduct defense when responding to an OSHA citation? That seems like a good place to start.
Sure, Todd. Well, the unforeseeable employee misconduct defense is legally it's an affirmative defense to an OSHA violation, and it's available to a contractor in a case where OSHA has that smoking gun. They've got either video or photographic evidence. And it all seems helpless at that point. But the law allows you this affirmative defense the unforeseeable employee misconduct defense, and it requires 4 elements. There are 4 elements you need to hit on to prove this defense. Number 1, the contractor has to have a safety rule that pertains to the alleged violation. Think of company safety handbooks. You're meeting element number 1 by referring to the handbook that may have the rule or law that in your company that has been violated and resulted in the OSHA violation. Element number 2 is to show that you are providing training on that work rule that you've just met with element number 1. And contractors are meeting element number 2 via toolbox talks or formal company-wide safety meetings. But what becomes terribly important, Todd, is that this training be documented. And what needs to be documented when there are toolbox talks or the safety meetings, the topic being covered, and it becomes terribly important to have an attendance sheet and have the employees signing in so we understand and know and can show OSHA who received the training. The third element is after you've got the work rule, after you've provided the training, you need to be going out to your job sites, self-inspecting your job sites. You can certainly engage a third-party safety consultant, but the key is having your job sites inspected for purposes of determining whether your employees are complying with your safety rules and understanding the safety training you're providing. So it becomes also critical in these cases to be documenting the job site inspection. And I can come back to that element in a second, because a common question, Todd, that comes up is, how often do I need to be inspecting my job sites, my various crews? And I could touch on that as we go forward. The last element, and really the one that seems the simplest, but it's the one that OSHA picks at the most when a contractor raises this defense, it's about administering effective discipline when the violation is discovered during your self-inspection. And we talk about effective discipline because the kind of discipline that is going to hurt your case is the kind that you have 2 or 3 employees violating the work rule at one time. Maybe it involves a supervisory employee. And in those instances, OSHA likes to argue, Your Honor, they seem to have a disciplinary policy. They seem to be documenting it, but we assert that it's not effective, Your Honor, because you have 2 or 3 guys at a time not really worried about the consequences if they're committing a violation, more than one person. So it becomes important to have really effective discipline. And it's effective when you're not having any repeat offenders, or you're not having a situation where more than one employee is violating the work rule at one time during that OSHA inspection.
So, Philip, is this something that is covered with policies and procedures and an employee handbook? Is that a good way to paper over this?
Yeah, the handbook's definitely going to want to cover the hazards that your employees are exposed to. And the other point I'll add, Todd, that's often lost in the mix, if you have English-speaking and Hispanic-speaking employees, make sure that manual is in both languages, because you'll lose out on that first element if your employees aren't understanding what's being provided to them.
Sounds like training is a big part of this equation. Are there some common mistakes that contractors are making when it comes to training?
It's another great question, and the answer is really where I see contractors tending to get into trouble on the training element is they're following a safety training program they pulled off the internet that really isn't tied to their business. The kind of training that ought to be focused on is focus on the training that pertains to the hazards your employees are going to be most likely faced with. I mean, think about the roofing contractor. If a roofing contractor is going to be cited by OSHA, it's most likely going to be a fall protection violation. These guys are up on the roof. There are fall protection standards. And in those instances, you want to make sure you're providing fall protection training. How much? There's no black and white answer, Todd, but, routinely. I mean, to have a toolbox talk on it, once a month, I don't think is too much. What concerns me, and maybe it's a better way to answer your question, is to focus on, where do people not doing enough? It's the company that gives that fall protection training maybe during the orientation at the time of hire, and then doesn't revisit it again for like 6 months or more. And in those instances, it's really tough to prevail on the unforeseeable employee misconduct defense. It's not a fancy name. I mean, the idea is you really have to be able to argue this was unforeseeable given everything we do in terms of the work rule, the training, our self-inspections, and our indiscipline.
Let's talk about the disciplinary policy for a few minutes. What's your guidance on what a successful discipline policy would look like that would keep contractors out of trouble?
So a couple things. One, in terms of the disciplinary policy, OSHA tends to argue these days they'd almost advocate for a zero-tolerance policy. The law doesn't require a zero-tolerance policy. I'll be very clear about that. What OSHA is picking at, and what I think is becoming problematic these days, is what is the typical progressive disciplinary policy, where it's verbal warning. There are 4 steps: verbal warning, written warning, unpaid suspension maybe, and then finally fourth, termination. And I think if you have that 4-step policy, that opens the door to OSHA to argue. And I mean, I do this. The solicitor gets up in front of the judge and says, "Your Honor, I don't know what you got to do to get fired over there." And it's generally a case that involves an employee that's been guilty of the violation 2 or 3 times. And they know that because we've been doing those job site inspections, and they're able to see from the job site inspections and maybe earlier disciplinary reports that this particular employee has been disciplined 2 or 3 times and he's still committing the violation. That's a symptom that your disciplinary policy is not strong enough. So it's reaching a balance, but I do advocate to my clients these days that 4-step process is maybe too lenient. And I understand labor is hard to come by these days. But I think the verbal warning, number one, needs to be in writing, even though we're calling it a verbal warning. And I just caution contractors who have 4 strikes and you're out that maybe that's too lenient under the eyes of OSHA and the judges that handle these cases. One word I wanted to mention about the inspections, Todd, in terms of the frequency. If you're out there inspecting your crews and the crew that proves not to be safe needs to be inspected more regularly than the crew who's proven to be safe over time. We want to be able to argue that this is unforeseeable. The crew that's proven not to be safe need to be subject to a greater frequency of inspections in order to prevail on that defense. And you hope through time, with the greater frequency, that they prove to be safe. So a violation that comes down the road, we can argue is unforeseeable.
All right, good stuff. We're going to talk about the issues of marijuana, medical marijuana, legal marijuana, big employment mistakes that contractors make as we get further into this interview. But let's take a couple of minutes and just introduce yourself. Philip, talk about your background, your firm, and what you do.
Sure. I appreciate the opportunity, Todd. So my firm is Hendrick Phillips Salzman and Siegel. We've been around since my partners started the firm in the early 80s. We are a construction boutique law firm with a national practice. I'm representing contractors. I primarily trade contractors doing commercial construction and public work. And within the firm, my primary practice is labor and employment law, where I'm doing a lot of OSHA defense work these days. I happen to be doing a lot of I-9 audits. I have contractors throughout the country right now being audited by ICE. Includes wage and hour claim defense, and general consulting within the labor and employment industry, Davis-Bacon Act compliance. We also review construction contracts for our clients. We handle construction disputes, and I also do a lot of collections work around the country. And it's the kind of collections work where there is a party on the other side that's retained an attorney and is arguing some basis for withholding payment. In most instances, we think it's just a smokescreen. But yet there's an attorney on the other side, so we're pursuing those collection items. It may be involve a payment bond claim or filing a claim of lien on behalf of a client. And my partners as well handle construction disputes, everything that you can imagine: delay claims, acceleration claims, defective work issues, change order disputes, anything that you would typically come across in your everyday construction practice. We tend to represent most of our clients in a retainer relationship because we don't want them not calling us, worried that the clock's ticking. We try to avoid problems on the front end so we don't have to spend a whole lot of money and time litigating them on the back end. But we have 2 partners. We have 4 other attorneys that work for us, and we do nothing but construction around the country.
You mentioned helping out with payment disputes. What is one tip you can give contractors to help avoid those payment disputes or get paid faster?
Absolutely, and it's right at there's no doubt. It's starting with your contract and getting out of a pay if paid clause. Now, in some jurisdictions, the pay if paid clause is going to be void and unenforceable to begin with, but those are few and far between. The best way to address a payment where it's tough to get paid, it's fighting that pay if paid clause. And generally, Todd, and this is important for your listeners, what I suggest contractor or subcontractors do when they're dealing with the pay if paid clause, try to negotiate some language that provides that, hey, if the owner is withholding payment because of a dispute with another trade, or you, Mr. General Contractor, then I'm still entitled to payment. And I would submit in a negotiation, maybe the trade contractor in that instance would be willing to accept the risk that the owner goes bankrupt or becomes insolvent. But we'd want in the negotiation to articulate, we don't want to be responsible for the work of other trades. We don't want to accept that risk. So that's where I would start. Work on your pay if paid clause. And then if the dispute is one just about whether something's a change or not, stepping outside the actual contract terms, then it's just about preparing your file and making sure you've reserved claims going back to your contract, because I would always, not always, but in almost all instances, we're advocating proceed with the work. Don't let them have an argument that you're in breach of contract. Proceed with the work, reserve your claim, and then we'll go about getting paid after or as we proceed. And then lastly, I always try to, and it's tough, but try to incorporate a provision that allows for interest in attorney's fees. That tends to motivate people to pay. But really, that pay if paid clause can be a killer, because if you're in a jurisdiction where it's enforceable, well, it is enforceable.
Let's talk about drug testing for a few minutes. I have conversations periodically with business owners who say things like, I have a drug testing policy, I want my people to be clean, but I don't think my competitors are doing that. It seems like they're hiring anybody off the street, and it almost feels like having a drug testing policy or a zero tolerance policy is a competitive disadvantage. Can you speak to that a little bit and talk about how business owners should think about drug testing?
Yeah, well, your question is a common one these days, and told a different way, I have contractors who have the drug testing saying, someone's tested positive, do I have to terminate them? And the concern is as you know, with labor these days, or a competitor who's going to hire that person. I hear this regularly. So why you would have drug testing? One, for some companies, it's a culture thing. You've got an owner that just has or a management team that just refuses to allow drugs in their workplace, and they're not so much concerned about the competitor or that these people may go work for someone else. Otherwise, one benefit for drug testing in almost all jurisdictions is if you've got a drug testing policy that in a state that has like a drug-free workplace act, that gives you a discount on your workers' comp premiums if you have a policy that complies with that drug-free workplace act in your state. For your listeners, most states do have that availability. Do have that available, and it's whether the contractor chooses to take advantage of that and thereby get the workers' comp discount. There's also, sometimes these drug tests are driven by a commercial general liability carrier requiring it. So I would counsel clients to see if they're thinking about dropping a drug testing policy. One, do we have an obligation to actually keep it in place when we consider our various liability policies? I mentioned CGL, maybe auto as well, workers' comp, unemployment. Whatever it is, it's looking to see if we have an obligation to, in fact, have the policy. Employment practices liability insurance would also be another place to look to see if you've got that obligation. And then there's the safety. There's a school of thought, and this bleeds into the marijuana issue you mentioned, Todd. When we're drug testing and we have someone that tests positive, are we a safer company? And is safety, what is our safety culture in terms of someone testing positive, and what is the safety issue, and do we want to terminate on that basis? It becomes a company decision. But the company that calls me and says, we don't want a drug test anymore, or do we have to fire the guy? And the answer is no. You don't unless you got that contractual responsibility to an insurer. You don't have to have a drug testing policy, and you don't have to have terminate someone if you do have the policy. You don't have to have a policy that says you're subject to immediate termination. There's no law that's going to require that. So each company is going to have to craft it on its own. The risk is when you have someone who's tested positive, and then you keep that person employed, and then they, God forbid, there's an accident either on the job site or involving a third party, and then they get a post-accident drug test and they test positive. Then you're going to have bigger problems from a plaintiff's attorney who's going to say you knew and you kept the person employed and put them back at the construction site. It's just a difficult, you've got two competing schools of thought on it, and Todd, there's no real good answer to it, but maybe some companies, your listeners, find solace in the idea that, I don't have to jump to termination. Mr. Siegel's telling me I don't have to jump to termination. Maybe we'll have someone go through an employee assistance program while they remain employed. That certainly is going to help the argument from that plaintiff's attorney I just got done noting. Otherwise, the companies need to decide for themselves whether they're going to, in light of the concerns you raise, if they're going to have a drug testing policy, and if so, what is it going to provide?
Let's talk about an issue that's been getting a lot of press in the last few years, and that is the issue of legalized and medical marijuana. What should contractors be aware of, or what are some things that are commonly misunderstood or not known when it comes to those topics that contractors should be thinking about?
Sure. Well, first, it's going to only pertain to those contractors in states that have either a medical marijuana law or allow for recreational marijuana use. What I think contractors are really unaware of these days is the potential of being hit with a discrimination claim when you do have the contractor who terminates an individual pursuant to a zero-tolerance policy. So you've got the contractor with the zero-tolerance policy, and then you have the employee who happens to be a medical marijuana card holder who either smokes or ingests medical marijuana outside of work after work is over, before they go to sleep. And they wake up every day, they come to work, and at no time during their employment are they ever showing any signs of impairment. And according to your drug testing policy, you have the employee subject to a drug test, maybe random, whatever the reason, you have the employee subject to a drug test, and they test positive because they are smoking or ingesting marijuana at night, and then the company reacts and follows its policy and terminates the employee. And what contractors need to know is you can't just do that these days, unfortunately, if you're safety conscious and have had this policy of terminating people if they test positive for drugs. You can't do that these days if you're in a state that allows for medical marijuana use, because what's happening is you have these plaintiffs' attorneys bringing claims. It's really the contractor in the state that has the medical marijuana law and a state the state law that's the equivalent of the Federal Americans with Disabilities Act. So you have a state disability discrimination law. And then you've got the plaintiff's attorney who says files a claim against the contractor saying, well, you have discriminated against my client because of their disability, and you never engaged in the process of the dialogue to determine whether there was a reasonable accommodation that could have been provided to my client that would have allowed my client to perform the essential functions of the job. So what is the reasonable accommodation that these plaintiffs' lawyers are looking for on behalf of their clients? It's the waiver of the zero-tolerance policy. And in fact, there's a big case. It's the Barbuto case out of the highest court in the state of Massachusetts, which happens to have a medical marijuana law. One that I call pro-employer, in that it has language that says, these guys, there's no employment protection in Massachusetts. There's no statute in the medical marijuana law that says medical marijuana card holders cannot be discriminated against. Yet in this case, and this really is the seminal case here, the court says, on its face, the request to waive the zero-tolerance policy in a situation where the employee has never exhibited any impairment at work, that's a reasonable request on its face. And you, Mr. Employer, you, Mr. Contractor, need to consider that, or in this case, needed to have considered it. And you didn't, so there is a disability claim here. Now, Todd, the contractor in that case and in similar cases around the country wants to argue, well, it's going to cause my company an undue hardship, and those are legal terms, undue hardship to provide that what you think is a reasonable accommodation. And the argument they want to make is there are safety concerns. And the judges are saying, well, show me the evidence. And the problem right now is there's no empirical or statistical evidence that's been able to draw a connection between the smoking or ingestion of marijuana the night before work and an increase of accidents or safety issues the next day. There are companies, as I understand it, that are doing this work right now trying to draw that correlation, but it's just tough to find that evidence right now. So it puts that contractor between a rock and a hard place, where really they have to entertain the idea of waiving that zero tolerance policy as it concerns the person that's got the medical marijuana card, because that person does have that underlying medical condition. And I would just caution those contractors to be providing training to their supervisory employees on impairment awareness. Because if the individual is impaired at work, I don't care if they're a medical marijuana card holder or not, if they're impaired at work, you can take action. But it's about knowing and being able to identify whether someone's impaired, and it would help your case if you could say, we had two people who had this awareness training. Supervisor 1 saw it. He called over supervisor number 2 to be a witness, and they made a determination that the guy was impaired. They sent him to testing. He tested positive, and we're terminating him. And that's a different case than what I started with, which is the person who's not impaired at work, no signs of impairment, but fails the zero tolerance policy because of their activities the night before work.
Good stuff. Thanks for that explanation. It's very helpful. Let's shift gears and talk about an issue that you speak about pretty frequently, and that is this worker an employee, or are they an independent contractor? This has been a big issue in the past. How concerned should contractors be about this? What can they do to mitigate the risk? And just talk about that a little bit, if you would, please.
Sure. Well, on this issue, and it is on my list of most common employment mistakes, what I caution contractors these days, it's still an issue. It's still an issue. It's not as big of an issue as it was under the Obama administration, because under the Obama administration, the Department of Labor had issued on this issue, one interpretive guidance memo that took the position that basically, unless you can argue that the independent contractor, the person your listeners are classifying as independent contractors, are really separate, independently established businesses making an investment, having subject to risk of loss or potential for profit, really economically independent, then they've been misclassified. And it starts with the idea that everybody's an employee, and then you had to fit within the exception to what they were articulating as the rule. Under the Trump administration, within the last 6 months or so, the Department of Labor has withdrawn that interpretive guidance memo. So we're back to what the law was before it changed with the Obama's Department of Labor's interpretive guidance memo. So what becomes important, it's a 7-factor test, and I'll just tell you, the control factor is going to be the most important. And what I caution clients, and to hit on very quickly, is making sure you've got a contract with the independent contractor. And I'm not suggesting that you should have a separate contract for each job, although that would be ideal. At a minimum, you should have a master subcontract agreement that is renewed annually. I think it hurts a case if the master subcontract agreement dates back 8 years and we haven't revisited it and we're only issuing work orders. I think having a master agreement that's revisited every year is important. You can issue the work orders throughout the year. That master agreement needs to want two terribly important clauses. One, the clause that expressly says this is an independent contractor relationship. And number two, and one I don't see a lot, I don't think a lot of attorneys are picking up on it, but I think it's important, including a clause that says the independent contractor can refuse work. I mean, if that they have the right to turn down a work order. That gives the appearance that independent contractor is really in business for themselves. So having that contract with those provisions really gets your foot in the door to be able to argue if you're ever under the microscope on this issue. The other thing I'll say that contractors can do to help themselves is two other things in practice. One, don't bring these people from job to job to job. If they're not working for other people, then you have to be the impetus in the break in the relationship. Your listeners do. Taking these people from job to job is going to be problematic if you're being questioned on the person's classification. And the second thing is, and again, I understand there's a practical reality here, but it's not having it's having the independent contractors separate from your employees, meaning you wouldn't want a job if you can avoid it. You wouldn't want to be at a project where you have the independent contractors working side by side with your employees, doing exactly the same thing as your employees, where someone comes up on the site and can't distinguish between who's an employee and who's an independent contractor. Those become problematic facts to deal with when it's an issue that's being investigated. So those are some key things to hit on. And I would also say, don't pay them by the hour. That's more indicative of an employment relationship. You'd like to be able to articulate that there's some negotiation that goes on in terms of the price. And we're not going to hit on all these. It's about, with the interpretive guidance memo being off the table now, it's kind of like we got to get it's a scale. We need the side to weigh heavier on independent contractor. We're never really going to have anybody that's perfect unless it's, a really, not someone we would be calling an independent contractor, but a sub, or, real business with real employees. But those are some pointers. I think you hit on those, and you begin to really give yourself a good argument that someone's been properly classified as an independent contractor if you've been challenged on it.
Okay, you mentioned that you have a list of the biggest employment mistakes that contractors make. Can you give us the top couple of mistakes that you see contractors make that they should really focus their efforts on?
Sure. Well, there are two that I see being made more often these days than others. And the first one I'll speak about, Todd, is contractors not understanding compensable travel time. Under the law, federal law, there are certain instances when you will have employees engaged in travel that the law says you have to pay them, and when you have to pay them, that's actually working hours. So you have to factor that travel time in addition to their production time, and in terms of what they're getting paid for, and in some instances that may throw someone into overtime. So there are two particular instances that I find contractors are not understanding, and this is based on my 20 years of experience defending contractors and wage and hour audits all across the country. It's a federal wage and hour audit. I do this in all states, and it's the contractor that doesn't understand portal-to-portal travel, which is your normal home-to-work travel, and how you can get in trouble there, and then the travel that falls into the overnight travel category. On the portal-to-portal travel, where the liability lies is the contractor that has these people, when they're coming from home to work, stop on the way to the office or stop on the way to the job site to pick up tools, materials, or equipment. I think about the most recent audit I've gone through. The investigator is meeting with the employees one-on-one. These are privileged interviews when we're talking about your non-exempt employees, the people that get time and a half when they're working overtime. Investigator meets with them one-on-one, and they hear through the interviews that these people are stopping to pick materials up at a Home Depot on their way to the job site. Well, when they do that, that puts the employee on the clock, and all of a sudden that becomes compensable travel from the time they stop at the Home Depot and do the work looking for the tools, materials, or equipment, and then continue in their car on the way to the job site. That becomes compensable travel time. And in fact, you have a policy, and again, problem area, real-life example. They stop at the Home Depot, then they come to the office, and then they go from the office to the job site. Well, again, once they stop at the Home Depot, they're on the clock. The travel from the Home Depot to the office is no longer in the normal home-to-work travel. It's actually in the category of travel described as travel that cuts across a normal workday, and that's compensable travel. And because we're in that travel that cuts across a normal workday, we're also catching the drive from the office to the job site as compensable travel time. Now, Todd, when I go around the country and speak on this topic, I have contractors, staring at me a deer in the headlights because they're not doing it right. And this is why it's mistake number one. Let me try to make your listeners feel a little bit better. If you're having to pay for compensable travel, you can pay it at the applicable minimum wage in your jurisdiction. Federal is minimum wage, sometimes state or local law allows for a higher minimum wage, you can pay a different rate for compensable travel than you have to pay or committed to paying for production. So that's where we often have a mistake. It's where we have people on the clock and the company not understanding they put the employee on the clock when they're stopping on the way in. On the overnight travel category, and this is really the bigger of the two, or the more common mistake between the two, first of all, overnight travel applies when your listeners are sending a crew out of state, or excuse me, not out of state, just where they're going to be spending a night in a motel or hotel, a night away from home. It doesn't have to be out of state. I shouldn't have said that. But they're spending a night away from home. So the question becomes, okay, they're headed to that hotel, motel, that base. When does that travel become compensable and thereby working time? Well, first I will say, if there is an individual who is the driver and he's assigned to drive, that person is going to be engaged in compensable travel regardless of when they leave on the overnight travel to get there and regardless of when they leave the job at the end of the week to come back home. That driver is working for you and getting paid. What about the passengers? Well, the rule is the passengers are on the clock and engaged in compensable travel when that overnight travel cuts across their normal working hours, even if the travel occurs on the weekend. So let me clarify that, Todd, with an example. And I've had contractors, when I speak around the country on this, say, well, I don't really have normal working hours. And my answer is, if you're under audit, the Department of Labor is going to interview your employees, and you're going to come out of that audit with the investigator taking a position on what your normal working hours are. So everybody does have normal working hours. Some know it, some don't. But let's go with the example of 7 a.m. to 3:30 p.m., somewhat common hours in construction. So you have these are the working hours, and it's Monday through Friday. The company's closed on the weekend. So you have the crew who is going to be taking a 5-hour drive out of town, and the crew is told to leave on Sunday so they can start first thing Monday morning. 5-hour drive. Normal working hours, 7 a.m. to 3:30 p.m. Monday through Friday. Well, if the crew leaves at noon on Sunday, 5-hour drive from 12 to 3:30, that's normal working hours. Even though it's on the weekend, your passengers are getting paid and they're working from 12 to 3:30. The last hour and a half, they're off the clock. But the 12 to 3:30 is compensable overnight travel. If your listeners would have told the crew leader, don't leave until 3:30, and these guys drive from 3:30 to 8:30, I already told you the driver's getting paid the whole time. In this example, because we're outside normal working hours, the passengers aren't getting paid at all. The whole 5 hours, they're not getting paid. So the message here is, one, the mistake is in not knowing that any of it is compensable. I mean, I do a lot of this work, and it's really starting with the idea, and excuse me, Todd, it's better put that the companies that are in trouble didn't know any of it was compensable. So the message I'm trying to deliver here is be aware that there is this overnight travel category, and if you're cutting across normal working hours, you have to pay, and you can pay it at a different rate. Now, again, when I speak around the country on it, people look at me really, people are not doing it right. It's mistake number one, and what I tell people here is your liability, if you were ever under audit, and this came up, the look-back period is 2 years. You're on the hook for 2 years' worth of back pay, unless the argument could be made that your violation was willful, and then they tack on a third year. So this isn't a never-ending liability. It's a 2-year look-back, but it's again, the mistake is not understanding that it exists in the first place and when it becomes payable. Mistake number 2 is not understanding what to do with an individual that has or is suffering from a medical condition or an injury. It's the employee. We've already passed the hiring process. We have an existing employee that we suspect has a medical condition or has suffered an injury, and we don't know if they're going to be able to do the work and do it safely. And it's contractors not knowing what to do and not seeking counsel on how to handle that situation. They're acting on their own, and what happens and how the mistake manifests itself is you're getting a charge of discrimination from the Equal Employment Opportunity Commission, the EEOC, or the state EEOC if your state has one. and the argument being that you've done something wrong, because there is a process, a step-by-step process basically, that the law allows you to follow to address some of the concerns that a contractor would have with an individual that has a medical condition or has an injury that we believe may impact that person's ability to do the job or to do it safely. So one, contractors need to first start with the idea with an employee, discussion about medical issues are completely off limits. I'll start with that rule. We need to be keeping things performance-based. In terms of disciplinary action, everything should be based on performance and not some perceived or actual medical condition. Now, with that being said, the law says if the company happens to know that the employee has a medical condition, maybe they've observed a guy suffer an epileptic seizure on site. I mean, Todd, that call comes into me twice a year at least. Or it's the individual, we hear from a credible third party that one of our employees has a medical condition. And based on what we're hearing or what we're observing, we have a reasonable belief based on this, what is objective evidence, that the employee's ability to perform the job and perform it safely is maybe at issue. And in those instances, and where the contractor is making a mistake is they're making decisions on their own. When the way to proceed is to, one, talk with the employee about the issue. And if you've got that objective evidence and the reasonable belief that the individual's ability to perform the job or perform it safely is going to be jeopardized, you can send that employee to a fit for duty test. And if it's one that involves safety, the law even allows your listeners for them to hire the doctor. The doctor needs to specialize. The employer-chosen doctor needs to specialize in the medical condition that the employee is suffering from. But this is all about avoiding the mistake and knowing that here's what I got to do. I have this reasonable belief based on this objective evidence. I need to send this employee to a doctor. And one of these other mistakes on my list, Todd, is making sure you've got a written job description that identifies the essential functions of the job, and that it's accurate, because you want the doctor to be looking at an accurate job description to opine whether this medical condition is going to impugn the employee's ability to perform and to perform safely. At the end of the day, we have to rely on the doctor needs to make the decision. If the doctor comes back and says, well, no, this guy can't do the job and there's no accommodations that can be provided, well, then your listeners are relying on the medical opinion to effectuate a termination in the worst case. Otherwise, the doctor may say, he can do it, but you have to provide these reasonable accommodations, a back brace for someone who's got a bad back, some reasonable accommodation. And if you don't have the argument that what the doctor is suggesting as an accommodation rises to the level of that undue hardship I spoke about earlier in the medical marijuana use context, then you're bringing this person back and providing the reasonable accommodation to allow the person to do the job and to do it safely. But again, the mistake is made in the employer saying, well, you've got this condition, I need to let you go, without counsel, without a medical opinion, and the mistake is not knowing what to do.
Thanks for sharing those mistakes. That's very helpful. We're coming up on time, and I want to be a good steward of your time. You've got an audience of construction business owners and leaders here. Is there anything else that they should be aware of? Anything that we didn't cover in here that you feel like they should really be made aware of and focus on?
Sure. Well, you're catching me at a time right now where I mentioned it kind of in passing during our interview here. The I-9s. You asked me last week. I might have had a different answer for you, Todd, but I'm just dealing, or maybe not last week, a couple months ago, but right now I'm just having too many clients subject to I-9 audits. And if you're subject to an I-9 audit, I will tell you that you get a notice from ICE, they appear in person, and you get 3 days to produce the records, the Form I-9s. And what becomes problematic is the scramble and the fire drill that you undertake in a worst-case situation of trying to organize, correct errors, provide information where it's omitted, and to get ready to produce these I-9s to the ICE inspector within those 3 business days.
Sorry to interrupt, Philip, but could you clarify what ICE stands for, which agency that is?
Yes, I'm sorry, Immigration Customs Enforcement. So you're catching me just at a time where I have clients struggling with this right now for several. I mean, Todd, for the last 18 months, I really didn't have any of this work. I did before, go back 18 months, and I was really busy with this stuff. I was making the news and everything. And then, while immigration's a hot topic right now, all of a sudden, in the political arena, it's working its way down. I'm seeing these ICE audits again. Several in the last 3 months, where I had a long period of time where I had none. But it's difficult to scramble in those 3 days. So what I'll leave your listeners with here is, go back. Let's do an I-9 internal I-9 audit. Let's make sure you have an I-9 on all of your current employees. And if you don't, there's a way to fix that. And the other piece I'll add is know the record retention rule with regard to I-9s, because if the law says you no longer have to keep it, throw it out. It can only buy you penalties. It does you no good. What is the record retention rule? It's holding these forms for 3 years or 1 year post-termination, whichever is longer. You're going to have one of these forms on every current employee. The retention rules are 3 years or 1 year post-termination, whichever is longer. So if you abide by that rule and you get rid of what you no longer need to keep, you're only going to help yourself. You'll discover that in an internal audit. The other thing is, if you're going to do the internal audit, make sure the person doing the audit is not the person who's charged with filling out the forms, because they're not going to be able to identify their own mistake. And if they're making a mistake, they're making it on every form.
Well, Philip, we are out of time. I really appreciate you being generous with your time. Before we wrap up, if folks want to get in touch with you, ask a question, potentially engage you for an issue that they're dealing with, what is the best way for them to get in touch with you?
Sure. Well, best way, pick up the phone and call me. My office number, 404-522-1410. That's 404-522-1410. I'm also checking my email regularly, and my email address, it's my initials, pjs@hpsslaw.com. That's pjs@hpsslaw.com. And that hpsslaw.com is our firm's email address as well. Don't be shy on any of these issues. If I've made anybody nervous, to give me a holler, shoot me an email, and I'll try to talk you down off the ledge.
Great stuff, Philip. Thank you so much for taking the time to be on the podcast. I really appreciate it.
Todd, thanks for having me, and thank the listeners for checking in.
Well, there you go. Hope you got something out of that interview. There's some stuff in there that will help you stay out of trouble and maybe even get out of trouble, if that's where you're at. To get your hands on the resources that we talked about, go to constructionleadingedge.com/074 for the show notes. And also, if you want to get your hands on that free video series of the secrets of successful contractors, you can do that at constructionleadingedge.com/owner. And if you want to set up that free business breakthrough call with me, you can do that by going to constructionleadingedge.com/call. As always, I appreciate the reviews. If you could take a minute, leave a review or a rating on the podcast player of your choice, that helps me get the word out and helps me know that you're getting some value out of this podcast. That's all I've got for you today. Until next time, I'm Todd DeWalt from constructionleadingedge.com. Thanks for listening.